SJC 12612, Commonwealth versus Weidman.
Mr. Riordan, good morning.
Good morning, Your Honors. Theodore Riordan for Mr. Robert Weidman. Your Honors, the first issue presented in this case is that the defendant's motion to suppress his statements should have been allowed because he was in custody and had invoked his right to silence. Well, that's a good point, but I think that follows up on this court's decision in Santos, that if there is any unclarity about whether or not the defendant is invoking his right to silence, it's incumbent under the Santos case for the police officer to ask a clarifying question, and they didn't do it in this case. Well, I think it was incumbent upon the police under Santos to ask what he meant by that. I don't know that this court needs to take a divining rod to find out what he meant. I think Santos says that the police should have asked. The second issue presented, Your Honors, is that the defendant did not voluntarily waive his right to remain silent, and his statements were not voluntarily made. She observed physical symptoms of withdrawal. We couple that with the defendant's, Maribelli's, the girlfriend's statements, that the defendant acted very oddly when the police came to their apartment. He offered them a cup of coffee and introduced them to his cat. I think the first time it turned custodial was when the police told him what Mirabelli said. Then she later came into the room and directly said it to him. So no later than that point when she came into the room was it custodial, but I would backtrack it to when the police told him.